Welcome to Ceasefire, where civics meets civility and engagement meets empowerment. Ceasefire is hosted by former Boerne ISD trustee and owner of the Boerne Bookshop, Dale Adams, and by former Boerne City Council member and local insurance agent, Ron Cisneros.
Good morning. Welcome to Ceasefire. My name is Dale Adams.
And I'm Ron Cisneros.
And today we're going to get back to our amendments to the Constitution, and today we're going to do the Fifth Amendment. And I'm going to flip through my handy pocket Constitution here, and the fifth one says, it's long, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That's a mouthful. Right?
Wow, yeah. I was telling you earlier, we come into these shows, and most of the time I have this fear that I don't know that I have enough for 30 minutes of recording. I always feel this insufficiency. And then we get in here, we start talking, and at the end of it, I'm like, gosh, we could have used another half hour. I think this is a show where we probably need a full 2 hours to take all of this down. It's quite a bit. There's
a lot, because there's multiple sections to this, and they cover different areas of governance and that are very important.
Yeah. So here's a breakdown, I think, of what we're talking about, 5 key points, and inside of those 5 key points, we could probably have another 5 sub-key points within those, right? But we're talking about self-incrimination, we're talking about double jeopardy, just compensation, grand juries, and due process. And in there, we'll talk about the takings clause, we'll talk about Miranda rights, a few other things. Let's jump into it, because we've got a lot to cover.
Okay, so one of the first things it talks about was the grand jury and why at the federal level, this is a federal amendment, you have to have one in order to bring charges for capital or infamous crimes. Why is that? Why should we have a group of ordinary citizens review a case before somebody's prosecuted?
Oh, man, I didn't know I was going to get quizzed today.
Yeah.
I thought you were the answer guy.
No, not today. You got a stack of papers.
Oh, I do have a stack of papers, and that was a topic that I wasn't really prepared to talk about. But that's a good question. I would think that it has a lot to do with the way this country was founded, where we were putting the basic rights in the hands of the citizens, and we weren't allowing the government to decide what rights we were granted. We assumed right from the get-go that these rights were ours, that they were inalienable rights, and that we were going to self-determine our government. And I think it puts everything in that, as we say, the jury of your peers, and they're going to decide, not some prosecutor with a vengeance or an angry judge. This is your peers that are deciding whether or not you've committed a crime and whether you should go to trial.
Yes. And one of the reasons that they put it in there is because a lot of that had happened under the king. They were tired of it, and they wanted their peers to have a say before the kings went around attacking everybody.
See, you did have the answer. You were just putting me on the spot.
Of course, yeah.
Yeah, and I want to add to that the due process clause, and this is very important, it protects all persons within U.S. territory, including, and this is going to make some people mad, but it includes corporations, aliens, and presumptively citizens seeking readmission into the United States.
Yes, and the slippery term there is due process, because how do you define that? And basically that can be whatever the legislature has properly voted on to be the law or the process for a given crime.
Yeah.
And that sometimes goes into uncomfortable territory. But the check on that is the fact that we elect our legislators, and supposedly that's supposed to help that.
Yeah, and in doing a little research for this, I thought, okay, let's find out where this idea of due process comes from, and it is from the Magna Carta all the way back in 1215. The first written form of it beyond that is in 1354. There's a statutory rendition of the Magna Carta that includes the phrase due process of law. So that's the first time that we see that phrase.
That goes back farther than I would have thought. I know the Magna Carta had a big deal to do with it, but I didn't expect that it was put into writing.
That particular phrase, that feels like I guess it would seem to us that it's a phrase associated with the founding of our country, really, not something that far back. But yeah.
But an interesting aside is when I went to live in England for a while, we were stationed there for 3 years, and I read a history of England before we went there. And I tell you, it was bloody, it was crazy, it was back and forth slaughtering each other all the time. But these things like the Magna Carta and these written things are what sort of created these requirements that we have to protect ourselves because they were abused so much. And over time, in England, they developed these concepts, and our founders took those and built them and wrote them into our government. In England, they're not really written so well as much as what they call the common law, which is what everybody assumes, but not really written down.
Yeah, big difference.
Yes, it's a huge difference because nowadays they're saying it's not written down, so we don't have to follow that.
Oh, gosh. So where do we jump to next?
How about the double jeopardy part? I found it interesting when I was reading about it is that it doesn't mean you can't be charged twice with something, because if the first time you're charged you get a mistrial, it means the judge did not actually come to a conclusion, which means they can charge you again. But if they come to a conclusion one way or the other, then you can't be charged again. And I thought that was an interesting distinction.
Yeah. Something else that I found interesting is that it doesn't keep a prosecutor from coming after you again or from splitting a case. In other words, if you committed several crimes, and so let's say that you stole a car, and in the process of stealing that car, you did a carjacking, and then there was a young child in that car. Now you've got a kidnapping, and so they can prosecute you for all of these other offenses
Separately.
Separately.
Yeah. And that's one way I think our government has gotten around the double jeopardy clauses. They've got so many laws about different aspects of a crime that they can charge as individual crimes, and suddenly you're able to charge somebody for 27 crimes for a given act. And I think that sort of defeats the spirit of the double jeopardy clause. I understand that they're saying, okay, you had a gun when you're doing something, you threaten somebody to do something, you hit somebody when you do something. Those are all separate conceptual ideas. But the act was somebody ran up and robbed somebody. And I don't know. I feel it defeats the purpose of the double jeopardy concept.
Yeah, I think if you can call it a pro, the reason they have that, or I think what I see is that they will take these, let's say it's 10 charges, and they'll only prosecute you for 1 or 2, and the others are leverage to bring you to the table and
or
to get you to
a confession.
Right.
Yeah.
Yeah, and that...
What happens with that is they'll have those 10 charges, and they'll say, we won't charge you with what you really did if you confess to some lesser crime. And that happens all the time.
Yeah.
But then later on, somebody comes and decides to pardon everybody, and they're letting somebody out who was convicted of a lesser crime, but actually what he did was really bad, and he should have stayed in jail because their record doesn't show that they actually did whatever the really bad thing was. And I feel if somebody does a crime, they should be charged for the main crime, some lesser thing. And I understand the whole rationale for plea bargaining and all that kind of stuff, but it just bothers me.
Yeah. Now, in the public's defense, we have Brown v. Ohio, and this was a Supreme Court case that I think applies here, and this is where they created the same evidence test, which basically says, and I think in this particular case, it was a guy who did use a car without permission, stole it, took it on a joyride, and so they prosecuted him twice, once for stealing the car and then for doing the joyride. And the Supreme Court said, hey, it's the same offense. You use the same evidence to prosecute the guy. You can't do that.
Huh.
Yeah.
When was this case?
Oh, gosh. I knew you were going to ask me that. I don't have that date.
That's interesting that there are some checks on that.
Yeah. Yeah, unfortunately, I don't have that date. Brown v. Ohio. If only I had a handheld computer that I could use and make calls with, too.
Yeah.
But
but it's interesting that there's a check on that then. So that I guess the issue is addressed to some extent. I'm not a lawyer, so I don't know the details.
I don't either. Sometimes I think when we do these Bill of Rights shows that we ought to have an attorney in this booth with us. But
I'm not sure of that.
Yeah, this show might need 3 hours then, right?
Go on forever.
And then a translator.
Yeah,
to get us
that's
past
right.
legal
that's right.
speak.
Right, get past the jargon. Yeah.
Oh, goodness.
Okay, that is interesting. So let's move on a little bit to the testifying against yourself. That's explicitly stated in there that you can't be forced to testify against yourself in a particular case. If the point of a jury trial or any kind of investigation is to get to the truth, you'd think that asking the person who did it might be a good way to get to the truth.
Yeah, this kind of reminds me of the, I can't remember which show I think it was the Fourth Amendment. You have these historical events that took place a long time ago, and they might seem antiquated now, but there's a reason that they were there. And in this particular case, old days, they could torture you into a confession.
Yes, the Inquisition went on for 400 years, and they did that.
Yeah. And so some of these, you hear them, and you're like, yeah, duh. And so you got to understand what was on the minds of the framers of our Constitution. Yeah. For them, it was recent. It was there. It was present in their lives. It wasn't old like it is for us.
Yeah. And actually, it still exists in a lot of countries. A lot of communist countries would have these confessional sessions and stuff like that, where people would have to confess to each other what they did bad. And so it still happens other places. And,
in marriage.
An interesting extension of this, though, is that your spouse can't confess against you.
That's
right. Can't testify against you, which I think is a good acknowledgement of the family bond, saying, look, you are a team. You're a unit. You can't destroy your unit. That's neat.
Yeah, and with that, too, we get the Miranda requirements, which I think are tied into that, and I think those are important, too. This Miranda, if you're not familiar, you've never been arrested, but that, and good for you, but that requires that before a suspect is placed into custody or interrogated, he must be given full warning of his rights. Yeah. And if I were smarter, I would have printed those and read those on air, but
I think the main one is that you do not have to testify against yourself.
You have the right to remain silent.
Yeah, the right to remain silent. But anything that you do say, we're going to use.
Yep.
So I think stating that up front is telling people about their rights. Yeah.
Yeah. By the way, if you want to dig into more of these, because we're not going to have enough time to go into all of this, there are some great Supreme Court cases on all of these things that we're talking about. So every single thing that we're going to bring up in the show has been challenged or questioned and worked its way up to the Supreme Court. And there are multiple cases that talk about all of these and how they're applied. And so, for example, in the case of Miranda, if I were arrested and my rights were read to me, and then I decided to start confessing some things, it's basically a waiver of those rights.
Yep.
And so there are all kinds of little exceptions and different rules, and I would encourage anybody to take a deep dive into the Fifth Amendment.
Yeah.
There's more than we'll be able to cover in the next however many minutes we have left.
Yeah. Unlike the Third Amendment, which hasn't been contested much at all or talked about, this one has been examined and cross-examined and challenged in multiple ways. So everything's pretty well defined within the legal world of how this amendment applies to everybody. But with that, we're going to take a quick break. Ceasefire with Dale and Ron, and we'll be back in just a moment. Boerne has its own bookshop. In fact, it's called the Boerne Bookshop. Hi, I'm Dale Adams, inviting you to get lost. Get lost in a good book in our relaxed and casual atmosphere. We have a wide and eclectic selection in the Boerne Bookshop, and we pride ourselves on finding what you're looking for. We do author meet and greets, host writing workshops, and can connect you with a good book club. And your young ones will absolutely love our kids section at the Boerne Bookshop. And while we want you to get lost, we're easy to find, as we're in the heart of Boerne at the back of the Richter Tavern building. We are the Boerne Bookshop. We're back with Ceasefire with Dale and Ron. We're talking about the Fifth Amendment, and we just went over the Miranda rights we talked about.
Yeah, double jeopardy.
Yeah, double jeopardy.
So here's one that I think is topical for today, and this is the exclusion or removal of non-U.S. nationals. And basically, the Supreme Court has said for a long time now that the power over immigration is given to the legislature, and they have almost absolute authority on that topic. We can dive into that a little bit later because there are certain cities and states that think that they have a little more power than the president or the legislature on this issue. But according to the Supreme Court, aliens seeking initial entry into the United States have no constitutional rights regarding their applications for admission.
Okay, because they're not here yet.
They're not here yet. In a 53 decision, they said that the government could deny entry to an alien without a hearing.
You'd have to have that because the entire world could write a letter and say, we'd like to have a hearing. You'd have to say, you don't have to.
And it seems sensible to me, seems sensible to you, but the reason it got to a Supreme Court decision is because somebody didn't think it made sense or applied. And I hear it, I'm like, duh, how would this be challenged? But it's been challenged, and not just once. So that I thought that was interesting. And here's another one, and this, I'm afraid, could take up the last 10 minutes of the show.
Okay.
It's public use and takings. And this one gets a lot of people fired up. But there's one particular case that I want to focus on, and that's Kelo versus the City of New London.
Yes. That's
2005 decision.
terrible.
You remember this one, right?
Property's still just sitting there.
Still sitting there. So for those that aren't familiar, this was a 2005 case, and in this particular case, the City of New London, which had been, this is located in Connecticut, and they had been in economic decline for years at that point, they condemned some property, and I don't remember, I think it was 5 or 6 or 7 homes, and they were going to turn it over to a private developer. And Pfizer, you all know them, they were going to come in there and basically bring in, I think, 1,000 new jobs. I'm doing this by memory here. I was just reading an article about this 2 weeks ago, so this is great that we're doing the show on this. But they were going to do this development and build a place for their new employees that they were going to hire. And the city was going to make over $1 million a year in new tax revenue. This went on for the citizens whose homes were being taken. They sued. It took about 3 years to resolve. The Supreme Court decided against those citizens. The City of New London decided that they were going to try and charge those citizens back rent for the 3 years that the case went on.
I hadn't heard that part. That's
it was
terrible.
It was terrible. The governor stepped in, and I don't know how he remedied that situation, but he did. In the end, the developer pulled out. Pfizer merged with another drug company, never moved into New London. At one point after, I don't remember the name of the hurricane, but that hurricane that blew through New England in 2010 or 2011.
Sandy. Yeah.
Was it Sandy? Okay. It left a large amount of debris and junk, and they used that property as a junkyard for a while.
Really?
Yeah. And to this day is still vacant, although what I read recently a few weeks ago was that they were planning a new 110-unit apartment complex for it. Finally, after nearly 20 years, they're going to do something. But the total cost of all of this, and this was shocking, was $78 million that was spent between the state and the city, and the 3,169 new jobs and the $1.2 million a year in tax revenues never materialized.
Yeah. And that's what happens when the government tries to pick winners and losers and decide, okay, we're going to let this person prosper. We're going to get rid of those people because they're not helpful to our community.
This topic we could do a 30-minute show on. This was a 5-4 majority vote. There were 4 dissenters, Thomas, O'Connor, Scalia, and Rehnquist. And I think their responses were wonderful and to the point. And I've got one quote I want to share with you. And this one's from Thomas. And he basically says, the beneficiaries are likely to be those citizens with disproportionate influence and power in the political process, including large corporations and development firms. I think he's right. And what's happened in this case, we moved so far away from the original intent, which was, hey, if we need to build a dam to save the city from flooding, or if we need to build a roadway to alleviate congestion, or if we need to take some property to build a sidewalk so that children can get to school safely.
Public use.
Yes.
Yeah.
And the Supreme Court decided that handing this over to a developer was in the interest of public use because the City of New London had been in economic decline. Just a horrendous decision. And nothing's changed in that city. They're still in economic decline.
And the fallacy with that verdict, in my view, is that they were looking at the end result and not at the process. And that in the Constitution and the way our laws work, it's all about the process has to be fair.
Yeah.
And they were focused on the result, which was supposed development and prosperity. And that's not the role of the law. The law is not there to make people prosperous. It's to make people have an even playing field and have a fair process so everybody can achieve whatever they want to achieve.
Yeah. I think I want to add this. One of the reasons we thought about doing this show was to talk to people about things like this, to get them to understand their government and how they should be involved in it. When we talk about things like the Fifth Amendment, it may not be as exciting as some of our other shows where we bring in guests, but this particular case highlights why it's important to always be cognizant of your rights and what's happening at the Supreme Court and the legislature. I think this was an egregious decision.
I agree.
After the fact, many states, and I don't remember the count, but it was something I was looking at preparing for the show, many states enacted laws that strictly defined what the purpose was for condemnation or taking.
Yeah. And I think they did that because the outrage by the populace was pretty high.
Yeah.
If you were around at that time, it was in the news quite a bit, and people were all like aghast that actually they rule that way.
Right. Yeah, and bear in mind that this is still, because of the Supreme Court, it is still the law of the land. Now, many states like I said, have enacted their own legislation now to properly define it, but there are still states out there that have not. And so this could come up again, and based on a future Supreme Court grouping, we might see it confirmed or we might see it overturned. But it is still the law of the land. Especially if you look through the eyes of precedent.
Yes. Let's take a sidestep here. I'm going to talk about the book I've got for today, and it actually doesn't have anything to do with the Fifth Amendment, but it's called Custodians of Wonder by Elliot Stein, and it's a book about people in the world who maintain ancient customs in the modern world. And so there's a story about they call it the last democratic position in Cuba, and it's the lady that reads to the people who make cigars, and they bang their knives or they cheer with their knives depending on how good she is. And it's a tradition that's been around for 150 years for the tobacco rollers there in Cuba, and they still do it. And she gets up there and she reads like Count of Monte Cristo and other books in the news and stuff to them while they're sitting there rolling their cigars, because it's a quiet process. And so she does that. And there's all these different traditions and customs around the world that you'd think are dying out or whatever, but they do still exist. And so it's a kind of a neat book, about 10 of them, and we got it at the Boerne Bookshop.
Oh, that's cool. I had no idea about that.
It's another book for your shelf.
It is.
He actually got it from a radio show that he did where he goes around and looks up all these small little customs and stuff. It's a British show, so it's not one we've heard here.
Okay.
It's a kind of a neat book.
Yeah. I can learn a little bit more about my Cuban history.
Yes.
All right. Hey, folks, if you like what you hear on the show and you want to get some more of it, Dale and I would like to invite you to Whiskey and Wisdom, a new book club that started late last year, and we meet every other month.
And that would be the third Thursday of April, June, August, October, and December.
Please join us. We're going to have an assortment of whiskeys there and a great conversation about a very interesting book. Hope to see you there. I think that's been a pretty good show. It's a good wrap-up point here.
Yeah, we can always, in any one of those, we could just take on as a topic too in the future someday, maybe. But that's it for today. If you missed anything, you can always go check out our podcast at bourneradio.com or even listen to our old shows. And thanks for listening to us, and we'll see you next week on Ceasefire. Boerne has its own bookshop. In fact, it's called the Boerne Bookshop. Hi, I'm Dale Adams, inviting you to get lost. Get lost in a good book in our relaxed and casual atmosphere. We have a wide and eclectic selection in the Boerne Bookshop, and we pride ourselves on finding what you are looking for. We do author meet and greets, host writing workshops, and can connect you with a good book club. And your young ones will absolutely love our kids section at the Boerne Bookshop. And while we want you to get lost, we're easy to find, as we're in the heart of Boerne at the back of the Richter Tavern building. We are the Boerne Bookshop.